Good morning, Your Honors. May it please the Court, my name is Brian Wilson. I'm an Assistant District Attorney in Norfolk County, and I represent the Commonwealth in this matter. The central issue in this case is whether asking or ordering the defendant to step out of a motor vehicle was lawful under the circumstances known to the police at the time that they gave that order. But the issue really raises the central question of, was this in fact what we typically consider to be an exit order?
When there's no question about the safety of the police officers.
That's correct. There's no question that the officers at the time that they ordered the defendant from the truck had no legitimate concern for their safety or for the safety of the public.
And he had not committed any kind of infractions in their presence.
That's
correct. He was just sitting in a truck, right?
He was sitting in a truck, but what the police knew up until that point, at the very least, gave them reason. In fact, the motion judge found that they gave them reasonable suspicion to believe that he had, in fact, committed a crime.
Why do you say that asking the defendant to get out of the car was not an exit order?
Well, it's certainly not a typical exit order.
But it's an exit order. I mean, you're saying it's not an exit order that requires dangerousness. But you can't say it's not an exit order. It's an order to get out.
It's an order to get out. But what Gonzalez itself, it's clear from the opinion that the plain language of the opinion itself stated that today we establish a bright line rule, and that bright line rule was that in the context of a routine traffic stop, the officers need some legitimate safety.
Well, your argument is that Gonzalez is limited by its language only to routine traffic stops and doesn't extend beyond that.
It's limited by its language, and it's limited by this Court's decisions since then. And certainly there have been cases, a few cases since then, certainly in the appeals court, that discuss the context of an exit order, whether an exit order was lawful, not in the context of a routine traffic stop, but in the context of the police, as in this case, having some sense that the defendant had committed some other crime, something more serious than a routine.
Wouldn't you need to go, I mean, as I understand the facts, accepting what you say, but they said nothing to him. They approached the truck and said, get out. I mean, they didn't ask his, isn't that right?
That's correct.
Didn't ask his name, didn't ask all the stuff that happened afterwards. He was already out of the car, right?
That's correct.
I mean, out of the truck. Doesn't that make a difference? I mean, I appreciate what you say, but they really didn't, until they could see him and sort of ask him questions. The idea of a one-on-one ID wouldn't come into play. I mean, there's a lot of reasons why they might have gotten him out of the car. It just seemed to be premature.
Certainly, it might have been the wiser course in hindsight for the police to ask him the same questions that they asked him after he stepped out of the truck. What are you doing here? Are those your bags? Things of that nature, in order to bolster their reasonable suspicion. But at the time that they ordered him from the truck, they already knew that he fit the description provided by both of the eyewitnesses in the case. And admittedly, it was a general description of a white male wearing a light-colored shirt and blue jeans. But they had no reason to believe...
That's all, isn't it?
It is all, but there were...
I mean, does that give reasonable suspicion to stop somebody?
Well,
I mean, taking him out of the car is really, you've got to admit that that is a stop, isn't it?
It's a stop. It's certainly some intrusion upon his personal liberty. There's no question about that. But there was nothing unusual about the defendant. Nothing. He was of average height, of average build. There was nothing, didn't have any facial hair. There was nothing unusual that the eyewitnesses would have pointed to that would have given any more of a detailed description.
Was this case decided under the Fourth Amendment or Article 14, or both?
Both. Well, it seemed both, but certainly the motion judge was following this court's...
Gonzalez.
In Gonzalez, correct.
That's an Article 14 case.
Yes.
So this, if he's right, then this can be, under Article 14, this is insulated from federal review.
Yes, and I don't argue today that this court should depart from Gonzalez and should follow Mims and Wilson and the other federal cases that provide for an automatic exit order. That's not...
So your position is simply that if there's reasonable suspicion, then they were authorized to seize him, threshold inquiry, whatever you want to call it, for a reasonable period of time to ask him questions. And that would include ordering him out of the vehicle, right?
ordering him out of the vehicle for the purpose, Your Honor, of effecting a one-on-one show-up, which is exactly what
Correct.
the police
But
did.
I'm just
Correct,
saying, but was it reasonable?
Can I just finish? It would be the same as ordering him out of a dumpster, right? You're saying the vehicle here is not a car that's traveling on a road. It happens to be a place where he's hiding, just like a dumpster. So ordering him out of the dumpster so he could be, go through a one-on-one show-up would be the same thing, wouldn't it?
Well, I would say it would be, because
Well, wait a minute. You've got reasonable suspicion, right? If somebody's hiding in a dumpster, it seems to me that puts a pretty heavy thumb on the reasonable suspicion. If somebody's sitting in a car, they're sitting in a car in a parking lot, right? And he's an ordinary,
But he's in-
nondescript, no facial hair. I take it from the Commonwealth's position that any white male that they encountered sitting in a parked car, they could order him out.
No, but this man was sitting in a parked car in an area to which both suspects said the assailant, both victims said that the robber had fled. So he's in the area that two people had pointed to. He's not backwards from that area or anywhere else, and it's close by and it's close in time, and he's wearing about what the victim said that he's wearing.
And I would submit that in the fact that he's in this third motor vehicle, that the motion judge really found that it was irrelevant. But I think the police at that point, seeing him in a third vehicle...
What do you mean in the third vehicle?
They're breaking into vehicles.
Because
Let's see how-
what he was doing was breaking into cars, and here he's in another car.
They could at least infer that there was the possibility that that wasn't his car that he was breaking in, that he had broken into that car as he had a few minutes
How do you
before.
square this with Gonsalves, which seems to flat out say, in the absence of any fear for their safety, they can't order people out of cars?
By saying that Gonsalves is limited to a routine traffic stop, and this wasn't a traffic stop because the truck or whatever it was he was in wasn't moving.
It wasn't
Isn't
moving.
that
and
your insight?
How did the
Your Honor, it wasn't
police
even
know
running.
this was the third car in which this man was sitting?
Because he fit the description.
Yeah, but you just told me it was a nondescript description. I mean,
Well, the police officer who testified at the motion to suppress hearing, the one who actually followed the route from eyewitness A to eyewitness B to the defendant, traveled that same route apparently that the defendant had, saw no one else in the area who even remotely fit that description. He fit the description of not only a white male, but one wearing a light collared shirt and blue jeans. And at that
how
point,
did he know he was
see the
wearing blue
jeans.
jeans when he was sitting in a car?
well, there's no way to tell whether the
So there's
officer
a
could
white
tell.
man sitting with a light colored shirt, like a white shirt, a blue shirt, gray shirt, right?
Correct, a light colored shirt. Certainly that the police had some reasonable suspicion to effect some sort of temporary detention. Now, as I read Gonsalves in the cases that follow, essentially the reasoning behind this court's opinion in Gonsalves was that in the context of a routine traffic stop where the officer has no reason to suspect that the motorist committed any type of crime whatsoever, perhaps nothing more serious than the traffic violation that prompted the stop, the degree of intrusion, applying the typical Fourth Amendment analysis, the degree of intrusion in ordering someone out of that vehicle is disproportionate to the degree of suspicion. And I submit that the motion judge actually was going down the right track in the beginning initially.
Well, he found there was reasonable suspicion, and he said, so therefore they could conduct a minimally intrusive inquiry, correct?
Correct. And then the issue becomes, once they approach the vehicle, what did they have authority to do?
Is the car essentially, or the vehicle essentially irrelevant in this case? If they had the authority to stop him, if he was walking down the street and they had authority to say, come over here, we want to talk to you about a recent string of breaks and have a one-on-one show-up. If they had the authority to do that, what difference does it make that he was sitting in a truck?
Well, certainly if he was walking down the street, they could have detained him for that one-on-one show-up, exactly.
And the
way that they
judge,
did
and the
here.
judge so found.
Yeah.
judge
So what difference does it make that he was sitting in a truck?
I would suggest it makes no difference where the truck wasn't moving, it wasn't a routine traffic
It
stop, and
actually
the
may
police-
help the Commonwealth, may aid the Commonwealth, the fact that he's in a truck, because the prior two breaks or crimes, if you will, would involve breaking into motor vehicles. So this might,
That just goes to the reasonable suspicion side.
well, but
Would you say that if he was walking down the street, that they could actually seize him in a constitutional sense to never mind.
Can't talk. Move on.
Could certainly talk to him if he was walking down the street.
I certainly talk to him, and I would
Hey,
suggest that
Well, we
If there'd been a string of burglaries in the area, and he, you know, they had some at least superficial data that he might match the description of the burglar.
And they could speak to him sitting in the truck, correct?
they certainly could speak to him, could ask him for identification, could ask him if that was his truck, if those were his bags, similar questions that they did once.
But the whole notion of what they were doing here is they wanted to look in that truck. And they couldn't look in that truck if he was sitting in that truck. Because then everything went downhill after that. They look in the truck and there's the Nextel telephone, then there's see the bags and all this other stuff. And they got him. Why couldn't they have just simply talked to him in the truck?
They certainly could have. And in fact, Officer Allison testified that when he looked into the truck itself, he could see through the open windows, not through the open door as the motion judge found. He could see through the open windows that there were bags, including one duffel bag, that at least for the general description of a bag that the defendant, or the perpetrator, I should say, was seen carrying from one of those motor vehicle brakes.
What do you mean when you say that the defendant's statements were not suppressed, nor the identification? I think you said that on page 24 or 29 of your brief, but the judge suppressed all the evidence obtained as fruits of the unlawful search.
Yeah.
And that would include the ID and the statement. So I didn't understand what you were saying there.
Well, I believe in that context, I was arguing that if the exit order was held to be unlawful, it would not taint the remainder of the evidence because it was wholly dissipated from the seizure of all the other evidence and the discovery of all the other evidence, including the one-on-one show-up, was the taint at that point had already dissipated.
How? How had it dissipated?
Because there was nothing to suggest that simply asking the defendant to step out of the truck and him actually doing so created the whatever nexus it was between that action and the evidence itself.
Mr. Wilson, may I just return to the issue of when the officer first noticed the bags? The motion judge discredited that portion of his testimony. Aren't we rather stuck with that? Or aren't you stuck with that? I mean, he makes that as and he explains why.
He explains why, but I believe the motion judge found something that wasn't supported by the evidence, and that was...
So are you saying that conclusion of his was clearly erroneous?
It was clearly erroneous from the testimony and the uncontroverted testimony, I would suggest, from Officer Allison.
Let me ask you this. So we've got, let's assume you're correct. We agree with you there's reasonable suspicion to believe that this person has committed a crime. Therefore, he can be detained for a period of time in question and can be ordered out of whatever depository he's in. Where do the police get the authority to then go into the truck and to take the bags and search the bags? Well, we're not, and this is not a weapons search, correct?
Correct.
You conceded there's no suspicion of safety here.
That's correct.
So where do they get the authority to do that?
From the statements that the defendant makes after he exits the vehicle, the fact that he said that he had just missed the time for getting into Father Bill's, which was a homeless shelter in Quincy, as the motion judge, I believe, found. In that would at least create some reason for the police to believe that that was not his vehicle, that he was...
Didn't he also say the bags were not his?
He also said the bags were not his, which may not completely result in the abandonment of any expectation of privacy in them, but would further lead the police to believe that the bags were stolen, especially where one of the eyewitnesses, the initial eyewitness who reported the crime to the police in the first place, had described the perpetrator as leaving his friend's car carrying some sort of a duffel bag, at least similar to what the police saw in the truck itself.
So when the defendant was questioned about and asked whether the bags were his, presumably when he got out of the car, the police saw the bags, at least that's what the judge ruled. They didn't see him before. They saw him when he got out of the car. That the fact that he said, no, those aren't mine, that meant what? The police could then open them up?
Well, at that point, with knowing all the circumstances, including what the police knew before they even encountered the defendant, the police at that point, I would suggest, had probable cause to search those bags for any fruits of instrumentality of the crimes, either the property that was stolen from either of those two motor vehicles or any instruments that the defendant may have used.
So
to
when he
break
said
in.
they're not my bags, that gave them probable cause, as opposed to if he said they were my bags?
It gave them probable cause, not in and of itself, but in combination with everything the police knew at that point, including the fact that he stated he had just missed a time for getting a bed, which would at least give the police some reason to suspect that he was entering that motor vehicle, perhaps even as a place to sleep. But at least that would distance himself potentially from the vehicle itself.
Thank you, Mr. Wilson.
Thank you very much. Your
Mr.
Honor.
Glennon?
Good morning, Your Honors. My name is Attorney Paul Brennan, and I represent the defendant, William Bostock, in this matter. The briefs were, the defendant appellee's brief was prepared by Mr. William McDonough, and the Committee for Public Counsel has submitted an amicus curiae brief to this court, which both briefs I've read, and I'm prepared to make arguments based upon both briefs. However, before you...
What did you seek to suppress in your motion to suppress? I don't think that was in the appendix. So what exactly did you seek to suppress?
Well, I've just read the motions. The motions are very general. In fact, they were catch-all motions, and I guess that the judge then would have been entitled to suppress anything that he thought had been improperly seized by the Commonwealth or improperly obtained by the Commonwealth. That would have included any statements that the defendant had made and any improper show-up identification. However, he didn't address those issues. He simply...
Mr. Justice, could we receive a copy of the motion to suppress?
Sir?
Yeah.
But he said to suppress, well, I suppose, evidence obtained as the fruits of an unlawful search.
In other words...
I understand you're making that claim that it covers the statements. I'm not so sure.
I think it was a giant vacuum cleaner, and it covers everything.
Well, he certainly moved to suppress statements and physical evidence.
Yes, yeah.
But,
And the judge didn't draw a distinction between the two, so I take it your position is that the judge, as a practical matter, suppressed both the statements and the physical evidence.
That's correct. That's correct, Your Honor. And before Your Honor ask me one more question, I would just like to say that I would like to address two matters discreetly. First of all, the reasonableness of the exit order, and secondly, no matter what you determine about the exit order, then there's the reasonableness about the propriety of the search of the motor vehicle. And I would therefore suggest that those are two discrete issues. They may be, in one sense, interlocked or interlinked, connected, but they are also two discrete issues. So first of all, let me address the question of the exit order. Most of the cases addressing exit orders, or overwhelming majority of the cases addressing exit orders, even before Gonzalez, always addressed it in terms of whether the police officer had justifiable apprehension for safety. And what Gonzalez did was said that we're not going to follow MIMS. There's not going to be any other. Whereas MIMS, the United States Supreme Court said that as a matter of course, a person can be ordered to exit the motor vehicle, and then subsequent decision that even the passenger can be ordered to exit the motor vehicle, and that they don't have to make any showing. It's just assumed.
But why does the fact that this person was in a motor vehicle make a difference in this case if the police had reasonable suspicion to believe that he had just broken into two motor vehicles and was breaking into this one? Why does it make a difference that it's a motor vehicle?
All right. First of all, I think the reason why we have all these, thousands of cases, not only before the federal court system and the state court system, is that because motor vehicles, there's an expectation of privacy. And that's why we have these disputes. In other words, when you ask the question, what does it make a difference if he's in a dumpster or in a motor vehicle? Yes, it does. I mean, if you're in a dumpster beside a 99 restaurant, you don't have an expectation of privacy. So the police officer can...
What's an expectation of privacy got to do with whether you can be seized for purposes of a threshold inquiry? It has to step away from the motor vehicle, step out of the motor vehicle, get out of the dumpster, get out from behind the building.
I respectfully submit it makes all the difference in the world. If I'm in a place where I don't have a legitimate expectation of privacy, I find it hard to imagine any grounds for a motion to suppress.
But they're not searching the car. Your expectation of privacy is in your body, your
That's
person.
correct.
And here, that is overridden by the reasonable suspicion to seize your person temporarily, to do a one-on-one show-up or to answer some questions as to what you're doing there.
With all due respect, that is not the case, Your Honor. If I may draw the Court's attention to an older case. That is the case of Commonwealth versus O'Loughlin. I think it's cited in the briefs. It's at 385 Massachusetts Reports, page 60. It's 1982. And this question of, I think this is the first case where I could find that where an exit order was tied to the question of investigation of a crime. And at footnote 3, and if I might just quote, on the basis of the suspiciousness of the defendant's action, the dissent argues that the officer's exit orders are proper. This is with respect to a motor vehicle. The propriety of those orders, however, does not rise and fall with the level of suspiciousness. No amount of suspicion short of probable cause could save an exit order from, or that follows the justifiable threshold of court inquiry.
But was that case, did that case involve a routine traffic stop?
No, Your Honor, that involved, I believe what happened in that case is that a police officer came upon a vehicle that was pulled over to the side and the person was inside, and I think he first made an inquiry whether or not this person needed assistance, and then it escalated.
That was Commonwealth against McLaughlin?
O'Loughlin.
O'Loughlin, okay.
But I believe it's Loughlin or O'Loughlin.
Loughlin.
Loughlin, yes. Yeah. Now, that's the first time. There's a categorical statement said that a statement from this court saying that for a person to be ordered out of the motor vehicle, absent of finding that there was reasonable apprehension by the police officer, there was requirement of probable cause. Now, I understand that there have been cases since then. We've taken, for instance, field sobriety tests.
So if you're right, if a police officer has reasonable suspicion to believe that a particular person committed a crime, all the person has to do is go inside his car, lock the door, and just sit there.
No. Yeah, I'm not going to say that. All right. I'm not going to say that. If you're in a motor vehicle and you've come under reasonable suspicion for a crime, you cannot be ordered to exit the motor vehicle. I would never go so far as to say that. However, I would simply say that if you're in a motor vehicle and there's reasonable suspicion that you've committed a crime, there's a simple standard that has to be applied, as the reasonable of the intrusion must be commensurate with the degree of suspicion.
Why is a car such a sanctuary? I mean, why is it different from, what makes it so special?
Well, I think the case law has established that one has
when you stop a car, yes, but this wasn't a stop.
Well,
a moving car.
Well, all we know, Your Honor, is that when Officer Officer Allison came upon the scene, he saw Officer Gata with the defendant outside the motor vehicle. We don't know whether the motor vehicle had been in transit before that. All we know is that the snapshot that we're first presented with is that Officer Gata is standing outside the motor vehicle with the defendant, Mr. Bostock. We don't know what happened before that. We don't know what was said. All we know is that
Are you suggesting that it actually is possible this was a routine traffic stop and that's part of this case?
Well, what we know is that Officer Allison said that Officer Gata ordered the defendant out of his motor vehicle. That's all we know. Okay. We don't know whether the ignition had been on. We don't know whether Mr. Bostock had been attempting to exit the parking lot that he was in at the time that he was stopped. We don't know that. But we do know is that he was in his motor vehicle. And
in his motor vehicle?
In
a motor vehicle.
In a motor vehicle, and
because the shelter was closed, and that's why
right.
he.
But it's not alleged that he was illegally in possession of it. If you're in a motor vehicle, I don't respect. There's a reasonable expectation of privacy. Granted, it is subject.
So you're not relying then on in a motor vehicle that this was a motor vehicle stop.
It's not a routine motor vehicle stop. This is a question of whether or not reasonable suspicion, and the judge found that there was reasonable suspicion for initiating contact with the defendant. There's no dispute about that. What's the dispute is whether or not surreptitiously ordering Mr. Bostock out of the motor vehicle was a reasonable investigatory reaction to that.
But just so that we understand, the claim here is not that he was ordered out of a car, out of a motor vehicle, in the course of a routine motor vehicle stop?
I don't think there's any evidence that it was a routine motor vehicle stop. All we know is that
Ordered out of a car.
it was ordered motor vehicle, and the judge found that there was reasonable suspicion for initiating the contact.
And are you contesting that the judge found that there was reasonable suspicion?
I'm not going to contest the judge's finding in that respect. I mean, he
Okay,
found-
and I mean reasonable suspicion in the Terry sense of the word.
That's correct. Yes, that's
Okay.
right.
Justifying a threshold stop.
Or you are not contesting that?
I'm sorry.
You are not
No,
contesting?
no, no. I mean, the judge's findings. I can't. I mean, the judge.
So what do you say the police should have done here?
Well, first
They
of
had
all,
reasonable suspicion.
I think if let me quote, the conduct of the officers must be proportional to the escalating suspicion.
So
that
what
a
should
more-
they have done?
So first of all, you go up to the person in his motor vehicle, say, "Can I have your license and registration, please? Name and address." In other words,
And give him a chance to
establish-
pull some sort of a weapon out against the police
Oh,
officer.
Why would you ask him?
I think, Your Honor, if you were to adapt that talk, we can just throw Gonzalez out the window
Well,
today.
we can conclude, because the Commonwealth conceded that there was no reasonable fear of...
There was no
of
reasonable fear, yes.
officer safety.
Right. So he orders...
Why would you ask him for his license and registration if it was not a routine motor vehicle stop? You don't do that when you knock on somebody's door to their house.
Well, I mean, I think, if you're making, whether it's a routine motor vehicle stop or an investigation of another crime, I think the logical thing is you ask the person to identify themselves.
But here, the police, the reasonable suspicion is that the defendant is breaking into cars, into motor vehicles. So it's not his car. And so there's no reason to ask. I mean, that's the reasonable suspicion, as the judge found. So there's no basis, no need to ask him for his license and registration.
Well, when he's ordered out of the motor vehicle, they don't know that it's not his car.
But the reason that they stop him, and the judge so found, is because they had reasonable suspicion to believe he was breaking into other people's cars. So it's just as if you stop a person on the street. You don't ask them license and registration when they're walking down the street because you think they've broken into somebody's home.
Donna, here's the situation. He's in his motor vehicle.
Not his. He's in a motor
He's
vehicle.
in a motor vehicle, all right. We have no reason to assume either way, but he's legally inside. He is legally inside a motor vehicle. He is entitled to...
No, the
No,
police
they
have
have reasonable suspicion to believe he's not in his own motor vehicle.
But they never argued. That was not ever argued during the motion. What we have here is a situation. They're investigating a series of break-ins. They're not investigating whether or not
But that's in the back of their mind. They believe that because, as the judge found, they had reasonable suspicion to believe he was breaking into motor vehicles. It's in their mind that this may be another one he's breaking into.
Well, Your Honor, I don't think that testimony of Officer Allison or any of the officers at the time indicates that at all. They were simply investigating a series of break-ins, not whether or not he was in possession of a stolen motor vehicle. That never came up. Never. And I don't think we can entitled to read, well, if they thought about it, they might have thought, this is a stolen motor vehicle he's in. You can think, if you want to be mind readers, Your Honor, you can think of a whole host of reasons why if they were smarter police officers, they could have thought this, and that, but they didn't. What they were doing, they were investigating a series of break-ins. They come upon a man who's in a motor vehicle. All right, they want to talk to him. He's a lone vehicle in this, I believe, he's a lone vehicle in this parking lot near where the break-ins had occurred. And the judge was right to conclude there was reasonable suspicion. They go up to him. Before they even ask him his name and address, they said, "Out of the vehicle."
Would you agree that if he were standing in that parking lot and they approached him knowing what they knew, would you have any problem with their saying, "Hey, you there, stop. We want to keep you here so that we can conduct an identification. We're going to bring 2 people to see you"?
All right. The question of a show-up identification, that's a legitimate question. I agree. Yes. If they have reasonable suspicion that he is involved in the break, of course, there are degrees.
Do you say
of
they could do
suspicion.
that without asking anything?
If after making the threshold inquiry, and they didn't make the threshold
No, I'm not.
inquiry.
I'm
All right,
asking
all right.
you
If
just
they
on
had
what
made
they
a
knew.
reasonable threshold inquiry while he was in the motor vehicle and determined this probably is our man, please wait here. The witness. Yes, that would have been probably okay.
No, but my question to you was, let's say they didn't say anything. They went up to him and they see that he's got blue jeans on and he's got a light colored shirt on. He's the only white male in the area. It is the parking lot where they know the victim said people went, but he's standing. He's not in the car. Would you say that they permissibly could say, you there, stop, we're going to detain you briefly while we get two people to come here and see if you're the person that just robbed them.
I'm sorry, is he inside or outside the car?
He's outside the car.
He's
There is
outside
no
the
car.
Well, if he was legitimately, and I say legitimately outside the car, and which I'm not conceding in this case, yes, they could say, for a brief show-up identification, yes. But that would be assumed that he was
So why
legitimately-
can't they say, get out of the car?
Well, first of all, they didn't make the threshold inquiry. They didn't. First of all, in other words, when they come up to a suspect, they have to have at least start the threshold inquiry to make sure that this is their man.
Mr. Glennon, what kinds of questions should they have asked him?
First of all, ask him to identify himself before they asked him to get out of the motor
What does
vehicle.
identification prove? So he pulls out a license or a social
Well, I
security
mean-
card or any, what does that
The
prove?
basis of the reasonable suspicion is auto break-in and theft. It's not driving without a license. So if they asked him to produce his license, the very least that would have happened is that he would be sitting in a car without a driver's license, so that simply would have added, he either did or didn't have a driver's license. But let's assume he says, I am, and gives his correct name, and and he brings out a driver's license, and they say, where's the car registration? And he says, I was just sitting here because I was tired. It's not my car.
Yeah, there we go speculating again. I can only go by.
Speculating, I'm trying to figure out what the nature of the questions. If in a routine traffic stop, the reasonable suspicion, the reason why you pulled over is because you've either crossed over a yellow line or turned right on a red when you shouldn't have, or your tail light isn't working, or there's something or other. It's a routine traffic stop. And therefore, the kinds of inquiries that the police make are relevant to the suspicion that you have been violating something related to operating a motor vehicle. Here, they're not interested in whether he's operating the motor vehicle correctly,
That's correct.
right? Maybe
Right.
they could have asked him for the vehicle's registration.
They asked him who are you, what are you doing here? And he might have had a legitimate, he could have asked, well, I have a legitimate reason for being here. They didn't do that. I see that time is up, and I just would like, before I go, just remind the court, I never got to address the question of what, even if the exit order
Mr.
was
Glennon,
correct.
you can rest happily on your
Chief
brief.
Justice?
Yes.
Can I ask, actually
You may
ask a
certainly
question
ask
on
a
that?
question.
Explain to me why, with your client having said, those bags aren't mine, the police had no right to look at them.
You need probable cause to search for evidence in a motor vehicle. I mean, this is not a protected...
Does he have a reasonable expectation of privacy in those
Yes,
bags?
I think the case law is that. I mean,
Bags that he
go
disclaims
back
are
to,
his?
Yes, going back all the way to Commonwealth versus Almeida. In other words, if you want to search for evidence inside a motor vehicle, you got to have probable cause. There's a situation where...
Well, he may have standing to raise the issue, but does he have a reasonable expectation of privacy?
yes, he's...
Of bags not in his car that he disclaims are
If
his?
I think, as the judge, motion judge correctly noted in his opinion, that if you're charged with a possessory offense, you have automatic, and it's found in alleged to be in your possession, you have inside a closed.
You have standing,
Space.
you
You
have
have standing,
standing,
yeah.
but do you have a reasonable expectation of privacy?
Of course, the bags are contained in a motor vehicle in which he is
Which is
lawfully
not
operating.
his, which is not his,
Still has a lawful expectation of
and
privacy.
bags which he disclaims are his.
Well, unless Your Honor thinks that he has no reasonable expectation of privacy of a motor vehicle that he's lawfully operating, maybe you're right.
Well, I mean, you're now saying he has a reasonable expectation
yes.
of privacy in an automobile that
Yes.
is lawfully operating.
Yes.
I agree with you.
Yes.
That's not this case.
So all this way, I disagree, Your Honor. Thank you.
Thank you.
Thank you, Mr. Glennon.